Hey friends, come on in, type in freedom now. Freedom now, guys. Freedom now. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law. We have some important news to discuss tonight, and I'm just trying to bring in some others here. Come on in, say hello. It's so nice to be with you. Type in freedom now, friends, and also tell me where you're joining from. Thank you so much for being with me. It is June 11th. June 11th, and I'm going to just give you a little play-by-play about what's happening with the litigation involving USCIS and their policies, their adjudication hold policies, as well as the other policies that we believe to be illegal, unlawful, and way too harsh and discriminatory. The re-review policy, the asylum hold policy, and the others. Let's get into it. Come on, guys, say hello. Say where you're joining from. If you're new to me, I'm an immigration lawyer in New York working with clients nationwide at McBean Law, where we believe in immigration freedom. It is the heartbeat of this organization. You may reach out to us at 914-898-9488 or info. Email us at info@mcbeanlaw.com to request a consultation. Tonight's update will focus primarily on what's happening with the litigation involving USCIS and its adjudication hold against nationals from 39 countries. Now, when we spoke yesterday, we discussed the fact that on last Friday, a terrific a terrific ruling came out of Rhode Island, which vacated the USCIS policies, the 39 country hold, the asylum hold policy, the negative factors, significant negative factors policy, and the comprehensive re-review policy. The court found all of those to be illegal and vacated them immediately nationwide. And then fast forward to June 9th, when the government responded to this action by saying we need further clarification, or the court needs to enter a final judgment so that we as the government can file an appeal in this decision and seek a stay immediately of this decision, because we don't like this. This is at the heart of this tugs at the heart of what we're trying to achieve with immigration enforcement here in the United States. These policies impact individuals here in the United States. So, Acting Attorney General Todd Blanche signed this motion. His name is on this motion that was submitted to the court on June 9th, and it made it clear in that motion that the government will wait until the court acts further or responds to that motion before they touch those policies. Now, on June 10th, yesterday, the plaintiffs in that Dorcas action filed their motion, and I'm going to pull their motion here. Although, the court has said that this motion is now moot, I think it's worth sharing the plaintiff's perspective, their point of view, that they communicated to the court yesterday in their response to the June 9th motion from the acting attorney general. The plaintiffs say here that 5 days ago, this court entered an order granting them partial summary judgment and vacating and declaring unlawful the immigration policies challenged in this litigation. Yet the government, by its own admission, continues to treat the vacated and unlawful policies as operative. As a result, and contrary to this court's unambiguous order, the government persists in withholding citizenship, green cards, work permits, and other essential immigration benefits from individuals who are impacted by these policies. Then it notes here that the language that the government used in their June 9th motion is really like a threat that has no basis in the law. They go on to say, however, that what the government is asking the court to do, as far as entering a final order, they do not oppose that. Plaintiffs do not oppose the court entering final judgment. Excuse me, final judgment under Rule 54B to facilitate an appeal of that order, because the government made it clear that its intention is to seek an appeal of the decision. Now, the plaintiffs also say here that the government's position, the way that they're treating this, it's like the court's order was just really a mere recommendation, which lacks, and this idea lacks any legal foundation. And let's see. And so that's the plaintiff's position, friends. They pushed back immediately on June 10th. Then today, okay, June 11th, June 11th, the court was not having it, so to speak. The court, you could tell from the tone of this order, from the Chief Justice here, that he was pretty annoyed by the audacity of the government to say, "Hey, we need clarification. Tell us what your order really means." The judge didn't like that, okay? And let's see if I'm going to pull up now for you on McBean Immigration TV. This is where you're seeing the content that I'm sharing. This is the judge's order today, June 11th, court order. It starts off by saying, just as a reminder, on June 5th, we issued an order granting in part plaintiff's motion for summary judgment and denying in part the government's cross motion for summary judgment. As the court explained then, under the APA, the Administrative Procedure Act, each of the challenge policies that USCIS enacted, they're declared unlawful, and they are vacated and they are set aside. And the government now wishes to appeal this decision, and that's their right to do that. That's fine. Then the court, there's more here as far as the court's push back a little bit on the attempt here by the government to do some things, legally speaking, that the court found to be unacceptable. I'm going to skip over all of that and just touch on the fact that the Chief Justice says here that some of the arguments that the government has put forward in their June 9th motion has really no basis in the law. It should almost go without saying, but the court will say it anyway for the sake of clarifying the government's current obligations, that court orders vacating and setting aside agency policies have immediate effect once they are issued. Immediate effect. And then the judge says here, in any event, the outcome here is the same. USCIS's challenge policies are no longer in effect. To be perfectly clear, this means that the challenge policies are vacated, set aside, canceled, annulled, revoked, and voided, and any other synonym out there, right? So the court did in fact enter a judgment here. At the end, it again reiterated the fact that these policies are contrary to law. They should be vacated and set aside. Okay, that's the first order that's entered here. Then it says a partial final judgment shall enter in favor of plaintiffs and against the government on counts 1 and 2 of plaintiff's complaint. And then, friends, it's the judge says here that within 24 hours, the government shall file a status report advising the court as to what specific steps it took or it has taken to comply with the court's order. So the judge is expecting to hear something tomorrow, okay? To hear something on Friday from the government, a status report. What steps did you take to to stop the USC the pause, to lift all of those terrible policies? Tell us, court, tell us, government, what you have done. So this is asking for an immediate response, which could very well be a one pager to be filed tomorrow saying, thank you for clarifying. Thank you for clarifying your order. And now that you've entered a final judgment, the government is prepared to prepared to, maybe that phrase will be used again, I don't know. The government is going to comply or prepare to comply with the court's order, and of course then we know that they're going to seek immediately an appeal, because that is what the intent is here by the government. And then maybe and then go all the way up to the U.S. Supreme Court. So what's next in this matter, friends, is the status update within 24 hours to the court. And then the government will appeal this decision. So this is the play-by-play on what's happening. So I'm expecting by tomorrow, for some sort of statement, maybe also from USCIS on its website, saying that pursuant to the Dorcas matter, they will comply. Right now, we're hearing, it's mixed feedback from various U.S. attorneys' offices across in the jurisdictions that where we have our lawsuits. Everyone's hands at this point is tied. They are only main justice, the the ones who are really in charge at the Justice Department are calling the shots on this one, guys. Your issue is a priority, major priority to them, because this is the real agenda with respect to legal immigration in the United States, to slowly shut it down. And it's under attack now by this tiny, tiny states and this huge order issued by a judge in this tiny state that that binds the hands of those in Washington, D.C. at this time. So they're not happy about it. And while, of course, we're expecting significant pushback. Now, you might be saying, well, this is great news. It is great news. It is great news. But because we know that the strategy is to frustrate, delay, and deny, and to just shut down, I'm expecting to just continue fighting all the way through for the next couple of years. It's still going to be a push, I think, because there are different ways of being creative to just, yeah, we're complying slowly. But we're complying, right? And so it's going to take quite a bit of pushing all the way through, I think, for some people to get their cases worked on. But in any event, this is the latest, guys. I will continue to keep you posted on what is happening with these policies and what's happening with the litigation, okay? Before I go, I'll answer just a couple of questions. Can you tell us an update about the 75 country? No, nothing has moved or shifted. There is litigation. There's even a class action, I believe, regarding the 75, if I'm not mistaken. Yeah, there is. There is. There has not been any outcome with respect to that case that I can discuss here tonight that I know of. And our case, we're still plugging away with our case that has been filed in Washington, D.C. Thank you, guys. Freedom now. Freedom now. Okay, can I talk to you, please? Absolutely. Feel free to give our office a call. The phone lines are open 7 days a week, Monday through, 7 days a week, guys. 7 days a week. And Monday through Friday between 8 a.m. and 8 p.m. and Saturday and Sunday between 9 and 6, 9 a.m. and 6 p.m. Um, all right, Freedom Now, Freedom Now. If you're part of our round one Boston lawsuit, you know that tomorrow we have a plaintiff Zoom meeting with you. We have updates to share with you. Thank you. What is our number? So check your email. Check your email for the Zoom link. The phone number at our office, you could reach us at 914-898-9488, or just check the bio page there on TikTok. Thank you. Can I hire an attorney at your firm to attend the N400 interview? Yes, you could have a consultation, start with a consultation so that we could take a look at what's going on with your naturalization application and whether we could assist you with your interview. We do, although we're based in New York, we work with clients nationwide. On the interview side of things, though, it gets a little tricky. We sometimes have to have local counsel in your area attend an interview with you. USCIS now requires in-person appearance of attorneys at their field offices. All right, guys. Thank you so much for being with me tonight. Be sure to, if you've missed any aspect of it, be sure to watch the replay on YouTube. It's 8 o'clock. I've got to get out of the office and go home to my family. So thank you so much. I will continue to keep you updated, and I will see you, friends, in the next one. Bye-bye.